Good afternoon, everyone, and welcome to another webinar from the TUC. My name's Anna, and today we're going to be talking about right to work checks and how you as workplace reps can support migrant members and colleagues. I'm joined by two guests today. Firstly, we've got Katya from the Migrant Rights Network, and we'll be hearing from her shortly. And even though you can't see him at the moment, my colleague Wilf Sullivan, the empty dining chair, but he's coming back in a second. Before we get going with the subject, as ever, we've got live captions on this webinar. There's a green button underneath the video screen, so please click that if you want to follow along with the captions. It's great to see you introducing yourselves in the chat panel on the right. Please use that to exchange any ideas or tips you might have for each other, and to just generally comment on what you're hearing. If you want to put any questions to our speakers, at the bottom of the screen, there's an Ask a Question button. So please post your question there, and I'll try to get to those after we've heard from Wilf and from Katya. So first of all, we're going to hear from my colleague Wilf, who's going to talk about the TUC's position on these new checks and what you as workplace reps need to be thinking about if you're facing this in your workplace. So over to you, Wilf.
Thanks very much, Anna. And I'd just like to welcome everybody and thank everybody for coming. And I'd especially want to thank Migrant Rights Network for partnering us with this. Migrant Rights Network helped us to put together a guide some years ago on document checks and workplace raids, which became a bit dated, and obviously with the changes now in terms of employers having to do electronic checks, it was a good opportunity for us to work with MRN again, and they've done this guide now, which I think will be very useful to everybody. But just to say a couple of things, really. One is often this is seen a very sort of technical thing, but actually in terms of the sort of regulatory regime around document checks, it's important to remember that actually what the law says is that employers will be fined if they're found not to have undocumented workers and that they haven't done checks. It doesn't actually say we'll have to do checks in X, Y, or Z ways, and that's the law. One of the reasons for that is that this is part of what I would describe as the hostile environment sort of regulatory framework, which often means that employers do things that to cover themselves that are either against the law or actually go much further than the law requires them to. And then document checks is one of those areas where actually if people aren't able to show that they've got a right to work, then often employers will sack them. And whether they've got an actual right to work or not has no bearing on it. And we've seen lots of examples of that over the years. Secondly, people often think, well, this is just about migrant workers. But this is exactly the kind of regulation and regulatory regime that ended up with lots of people losing their work, their homes, and in some cases being deported in terms of the Windrush scandal. If you can't say, I've absolutely got a right to be resident in this country, never mind your nationality, then actually you've got a big problem. Because I'll tell you, if somebody asked me to prove that I have a right to work in the UK, I would find it virtually impossible to be able to do it. The third thing, is this is like outsourcing the border to employers. The regulations and the rules around immigration are horrendously complicated. I remember reading an inspection report from the Inspector of Prisons who said that people in the Home Office didn't even understand the rules. So let alone, that causes all kinds of problems when it comes to employers. And we know that in that kind of circumstance, when there's those kind of doubt, what happens is people start to profile their workforce. We saw it in the early days of document checks. I remember at one of the hospitals in London, they just told all the black staff to come and show their documents. And the staff actually took industrial action in that instance to stop it. But, discriminatory behaviour very much becomes a feature of what happens. So the last thing I'm going to say is that this isn't just a technical issue, it's a collective bargaining issue. We can't let the employers decide how to do this. We have to get in there and try and negotiate what is going to happen. Not least because actually we know that some of our members are incredibly vulnerable. And actually, if there's a question about whether people have a right to work or not, we should make sure that actually there is some space to be able to sort that out, that employers don't just pull for the sack switch, which is what they do so often. So I'm going to stop there and hand over to Amora, who can tell you a little bit more about what the changes are that are now taking place.
Thanks, Will, for that great introduction from the TUC's perspective. So now I'm going to bring up Katja from the Migrant Rights Network. And just while she's introducing herself, I'm just going to get her presentation loaded up. So bear with me for 1 second. Katja, over to you just to get the introductions going.
Okay, so hi everyone, my name is Katja Didlak and I'm the Community Project Manager at Migrant Rights Network. We are a charity that works alongside migrants in the fight for rights and justice. And what we try to do is to seek and bring people all together and share our collective resources and expertise to build solidarity between movements, campaigns and communities. So that might take many forms, but part of my work is to develop resources to inform people of their rights and how to advocate for them. So if you have migrants members in the workplace, please share some of our resources called Know Your Rights. This is a specific guide that provides information on everyday life. So how to access, a bank account, mental health, things around employment, exploitation, housing, and so on. As Will explained earlier, the MRN did a guide in 2010, and we feel that this revised guide now is a necessity because of the consequent changes post-Brexit and post-pandemic on how the right-to-work checks are conducted. Some might be aware that the UK government has the ambition to fully digitize the country's immigration system by the end of 2014, with introduction of digital-only immigration status and removal of physical status. And as you can see, this process is well underway. It started in 2019 with Europeans post-Brexit that had to register for a digital-only EU settlement scheme for their status, followed by Hong Kong British national overseas visa holders in 2021, and is now incorporating most migrants, regardless of being third country national or the status. I'm just going to check where you are with so the next slides. So bear with me. So today what I will do is I will summarize really briefly what's included in the Right to Work guide that have been shared on the side. So what rights to work checks are and why they are being conducted. What are the noticeable changes while conducting right to work checks since the 6th of April 2022, and what potential issues can emerge from those checks, and how you can actually support your members and your colleagues in the process. So that slide now. So right to work, you all know about it. You've probably heard a lot about it. And what do they mean? So in the UK, it's been made illegal to employ someone who does not have the permission to work. So one, we know that it's not mandatory for employers to do those checks. If it does carry one, if an employer does carry one out, it will have a statutory excuse against a civil penalty for employing a person illegally. So it's incentivizing the employers to actually carry on these checks, but they're not mandatory. There's no legal obligation to do that. So what the employers checks specifically is that someone has a right to work in the UK, the length, for how long, and to see if sometimes they're prohibited from undertaking specific type of work. So if someone is sponsored to be a nurse in the UK, in the first place, they might just be able to exercise that profession. Sorry, I think next slide, please. Yes, the next slide.
This one is about 3 possible ways of carrying out these checks.
Yeah, sorry, I couldn't see it. Yeah. So until recently, so until the 6th of April 2022, there were 3 possible ways for carrying those checks. Some online, through the Home Office immigration database, like I explained to you with the EU settlement scheme, people have a digital status, so you have to log on into that system, and if you want to share it with an employer, you can. That creates a specific share code that you send to the employers for them to access your profile and all the information about your right to work. Manual rights to work checks, which I think a lot of people are familiar with the employer inspecting specific physical ID documents. And until recently, until actually the 30th of September, that was the last day, employers, because of COVID-19, could have adjusted virtual right to work checks, where actually you could scan or send a picture to the employer and for them to have a video conference with you, and then you will hold your passport or that identification to check that it matches. So that's what happened until the 6th of April 2022. So next slide, please. So what has changed? So fundamentally, it's how non-British national and non-Irish national prove their right to work. The changes to acceptable list of documents, the guidance to enable employers to use identity service providers, and I will explain to you a little bit more about that, to carry on digital identity verification, and the end of the adjustment, the COVID-19 temporary adjusted right to work checks. So next slide, please. So what has changed? So, oh, sorry, no, I should have stayed on the same one. So what has changed really, because I need to explain a little bit more for you for that. So since the 6th of April 2022, in fact, the Home Office has introduced changes to the right to work checks. So the Home Office now imposed the rule that employers can only carry out right to work checks online if the employee is a holder of a biometric residence permit, a biometric residence card, a frontier worker permit, or holds a pre-settled and settled status under the EU settlement scheme, which is pretty much like the majority of migrant workers. So as I explained to you, EU nationals first were introduced to those digital checks, and after more categories of migrants with, and now from the 6th of April, pretty much all migrants. So in addition, so that changed the acceptable list of documents. So if you check from the guide, you've got a list A, a list B, part 1 and part 2 that will explain to you the kind of documents that people can provide to check to show that they have the right to work. So consequently, now that most migrants have to only do it digitally, they don't need to provide paperwork. So they cannot do physical right to work checks. So that list is changed completely. So what you need to do is to make sure you always refer historically to all the different, so depending on the employment of someone, the date they've been employed, you always need to check like what was the rules at the time. And in addition to that, the Home Office now has introduced a digital right to work check services for British and Irish nationals who hold a valid passport or an identity card. The employers can now use the identity service providers, they call IDSP, to conduct such checks using identity validation technology. Whereas like all the other migrants with BRP, BRC now cannot conduct manual checks. The things about identity service providers is that if they conduct those checks on behalf of an organization and an employer, they do, if they conduct the checks wrongly, the employer is still liable. So I don't really understand why you will outsource something and still be liable for the mistake. But I think probably the government and the Home Office have bigger plans for the future. So, and obviously that's at the end of the COVID-19 temporary adjusted right to work checks. So next slide, please. So as a consequence, so I try to explain to you what happened up to the 6th of April, what are the changes, and now how the right to work checks are conducted. So from now on, you can only do manual right to work checks. You can do it if people, British people and Irish nationals have a valid passport or ID documents card, they can do it using those identity service providers. I don't see the point, but why not? Or a Home Office online right to work checks. Next slide, please. So what we know from anecdotal evidence is that a digital-only system creates real risk of harm, of discrimination, there's concern around security, and further risk of those who are digitally excluded. So when the EU settlement scheme was rolled out, a lot of people couldn't apply on time, and as well from a report from the 3 million to the to a different body, they find out that a lot of people actually cannot access work, benefits, or rent because the system is not really working properly. And sometimes there's delays, so they miss out on specific like opportunities. So on the surface, they might seem straightforward enough, you know, those this introduction of digital checks, but in fact, it's another method for enforcing the government's hostile environment policy, like we have said. Many employers, they're using those apps now to verify a migrant's rights to work, which is completely incorrect. Like I say to you, it's specifically only for British and Irish nationals. So this is a really complex issue and confusing issue because that incorporates aspects from employment law, data rights, and Home Office application processes. So that's what it's important to understand. It's not a straightforward system. So the law itself is implemented like pretty much in a vacuum, and that lets some employers to shift literally the responsibility into the workers. So some of the issues that we have identified at MRN are those ones. So some of these checks, digital checks, have the potential to be discriminatory because, you know, the IDVT technology use facial recognition software. And we know from civil society organization that the algorithm and those technology are racially biased so as well. So this is a concern for us. We, from a lot of different platform and seminar, and I've even like run a specific one for employers and charities, I I think a lot of employers do not understand how right to work checks should be conducted, and do not understand what is the right to work. So there's a link, to everything that I've in the presentation, but there's a specific story around in The Independent about Rohi. She was a refugee. She's a refugee. She extended a leave to remain at least 3 times. She's been here for nearly 10 years. And despite being employed for 7 years for a charity, someone said to her, the time she renewed a leave to remain, she shouldn't be able to work. So they dismissed her. So she's on the brink of homelessness and destitution. So it's unfair dismissal, and it's just because the employer doesn't really understand what they're doing. Whereas like a lot of people are in that situation when they have to re-extend their visa or renew a visa, and it's quite common, but we feel like with digital checks, employers are a bit nervous, not knowing the outcome of that visa application. So sometimes they might not offer a position to someone just on that basis and not take the risk, or unfairly like dismiss someone just by not probably knowing that what they're doing is wrong. We know as well, like I explained earlier, from people that have been using those services for a few years now, that the online government employers checking services and the right to work apps do not work, and they're prone to error. So some people have been sent, employers have received sometimes like someone else's profile, or it happened that sometimes the platform was not available for a couple of days or something like that. And there's a lot of technical issues with it. And a concern is as well the use of third-party providers' apps and checking system means that someone's personal information now is literally at the mercy of others, with little to actually no choice for the workers. And as I explained to you, the government has launched those identity service providers. They don't need to be certified. It's recommended, but it doesn't need to. So at the moment, there's a digital market where there's nearly 400 providers, part of it, that will probably offer employers on their behalf to check, apparently, like straight away, like someone's right to work, despite that the law said that it's only for British and Irish nationals. So everything is still a bit confusing. So it's about making sure that people are aware of it, and then be tracking to know where this data is collected. Is it shared with those business, private, like third-party providers? So next slide, please. So how to support your migrant members and colleagues. So I've just taken a few examples from the guide. So I think the most obvious one is to make sure that, if you can, read the employer's written procedure for the recruitment and selection of workers, and make sure that it's actually based on equal and fair treatment for all applicants, especially on the right to work check. So, for example, to make sure that they don't discriminate because they need someone to have a specific status. Check as well if your union provide immigration advice, because despite being right to work checks should be, like an employment law issue, it's as well an immigration law issue, which is quite confusing for unions because, you need 2 levels of expertise, and sometimes it's 2 different words. But a lot of unions I know are providing immigration advice. Otherwise, you can always refer your member to OISC and SRA registered immigration advisor if they need assistance in terms of renewing the limited leave to remain, or as well to apply for indefinite leave to remain prior to the repeat check. Something really important, like I said to you, in Rohi's case, for example, she accrued 7 years of services as an employee. She was unfairly dismissed. And sometimes, because the thing is, like, it's a fear. It's not only the employee not understanding what to do with his status, but as well the people, because it's so complicated. So she didn't seek advice. And obviously, to put an employment tribunal claim, you're limited in time, and that's a problem. So it's to make sure that if you know a member being unfairly dismissed or discriminated against, that to make sure that you reach out as well to an employment or an immigration advice to make sure that you don't miss out on the employment tribunal deadlines, and that both matters are they're sorted together simultaneously, not one after the other, because sometimes people think they need an immigration matter to be sorted before doing the employment. So help members to compile relevant document to evidence their right to work in the UK as well. That's something you can do. Or ask your employers to do, but in a consistent way and a fair way, to make sure that whoever needs it, it's provided to them. Next slide, please. And to finish, pretty much, is we launched a couple of weeks ago our Challenge the Checks campaign. For us to raise awareness on how immigration enforcement and the workplace is affecting migrant workers all over the UK. Our stand at MRN is like, we believe that those checks should be removed completely. We shouldn't comply to any of this, because we feel like it's actually a tool to discriminate and divide workers. So if you want to know more around that campaign, if you know people that are affected, please go on the website. The link is inserted in the presentation. And if you feel like someone wants to share this story, or because we're collecting evidence to put a case together, so email policy@migrantrights.org.uk. And then lastly, I think I put a list of publication, obviously the guide, the TUC MRN Right to Work guides, the guide that Wilf mentioned earlier, because I think it's still relevant, especially in terms of like race relation and some of the tips and the case studies. It's really, really relevant. And all the other links are links to government legislation around right to work checklists, all these kind of things, because sometimes there's so many of them. It's about navigating that. So thank you for listening to me. And if you got any question, I think now it's time for questions. Thank you.
Absolutely. Thank you so much, Katia, for that really comprehensive outline of what the checks are and what people need to be aware of. We've got some questions posted, but I actually had a question that I thought of while you were both speaking that I'm going to put to Wilf in a second, but it does tie in nicely with a question we've had from an audience member. So my question was that, Wilf, you mentioned that this is a collective bargaining issue. So my question was going to be, what are the issues that reps could collectively bargain about? And the question that we've had from the audience that I think links with that is, what's the best practice or gold standard approach employers could take around this? Because it would be useful if we could take that idea to senior management as part of collective bargaining as a suggestion, so that they don't have time to come up with a terrible idea. So I'll put that to you first, Wilf. What should we be asking employers to do through collective bargaining?
Right. I mean, there's two major things for me about this. One is that actually they seek agreement with us about the way that checks are going to be done and when they're going to be done. And certainly from a union point of view, we would want them, if they're going to be done, we would want them to be done in-house. We wouldn't want them to be outsourcing to some private company, because there's all kinds of issues there around people's what happens to people's data as well. I think, secondly, if there is a question over somebody's right to work, then actually what we want to negotiate is a period where we're actually both the union and employer can work with the member to try and resolve that. Because often those questions arise because of the inadequacy of the Home Office and the Home Office systems. And what this frightens me in terms of doing it digitally. The problem with computer systems, if you put crap in them, crap comes out. That's well known in terms of Home Office computer systems. So if employers are looking to the Home Office to verify whether or not people can work or not, they're not going to get very accurate information sometimes. Often they're not even going to get a response. And what we must ensure that members aren't just automatically sacked as a result of that, and that they're given that we can work with employers to resolve those situations. Thirdly, I think one of the things we have to say to employers is, look, most of all this information that you're requiring people to provide is either state information or information that you have. If you're sponsoring an employer and you're putting in an application and you've got the information, you've got the information about people's work record, reversing it and trying to make it the employee's responsibility to prove that they should be able to work when actually employers have employed them often for years. It's just ridiculous, and we need to make sure that we try and make sure in our negotiations and agreements that doesn't apply. Lastly, it's about the extent of those document checks. I've come across lots of multi-employer workplaces where the cleaners are outsourced, where the agency workers are, and employers are saying to those workers, "Well, you're going to come and prove that you can work here." No, they don't, because they're not the employer. We should be saying to employers, well, if you've got agency workers, all you need to say to the agency is, well, you give us an assurance that people are able to work in the UK, not to actually take on that responsibility as well. And that's quite important, because those people are often in incredibly vulnerable positions in terms of their employment status and the information around it. The more you're casualised, the more difficult this gets, because your employment's changing all the time, and therefore information around what the Home Office have or haven't got, or what you have or haven't got, is really becomes really difficult. And I think the final thing I have to say, and it's a general point around this, because often people fall into this trap of talking about the narrative about whether people are working legally or not. As trade unionists, we cannot allow the idea that working is illegal, right? It's the thin end of the wedge. It's actually a human right. People have a human right to be able to go out and work and earn a living for themselves. And so we're not talking about people working illegally. We're talking about, in terms of the UK regulations, about documents that people have to show that they can work. That's what we're talking about. We have to be challenging that narrative with employers as well about that, and not letting employers get away with talking about whether or not workers are legal or not, because no worker is illegal.
Thanks, Wilf. There's some really key points there that hopefully you'll be able to include in collective bargaining. And just a point from me on collective bargaining, as with any workplace issue, we would always encourage you to don't consider it as an individual issue. There's normally going to be more than one member in this situation. So the technique we always come back to is map your workplace, map your members, find out who your members are, what their issues are, and you'll probably find that there's some marry up there. There's more than one person with the same issue or any other issue. We use the same method for everything really, don't we? Health and safety, equalities, checks, etc. Okay, let's have a look at another question. A quick question for you, Katia. Someone's asked, can you just clarify, did you say it's not mandatory for employers to do right to work checks? Is that correct?
It is correct. It's never been. It's been introduced in the 90s. The thing is, if you've got immigration enforcement officers coming into a workplace, for example, in a building, you just need to be able to prove that that person got the right to work. If they find out that that person doesn't have the right to work, they fine. So they're trying to incentivize or try to make it like so punitive for employers, like employing someone without the right documentation, that they conduct the checks. You know, they're not mandatory, but they do it another way by putting a fine and up to 5 years imprisonment. So yeah, they're not like small fines. It's like it's £20,000 per workers, but they fine. So yeah. So
thank you for clarifying that. Another question here that I'll put to you first, Katia. Is there a difference between migrant and refugee working in the UK and the checks that are needed?
For migrants and refugees, because they have a status and most of the time a biometric, they are conducted digitally now. But for asylum seekers, they have an application registration card, which checks needs to be done manually. And it's explained in the guide around those cards. So, you know, they need to obtain, you know, the card, the documents, and a positive verification notice from the employer checking services. So, you know, employers, they obtain the document, they check the document, the validity of it, they copy, and then when that person, you know, needs to repeat for the checks, because obviously if you are an asylum seeker, you're not an asylum seeker for your life, so you have to contact that person, because asylum seekers can work as well within the shortage occupation lists if some of the job they're able to do and look for. So yeah, so there's no difference in how you do the check. Like I said, for people who have refugee status and any other migrants, to the difference is mainly for asylum seekers. I hope you answered that question. Yeah.
Wilf, go for it.
Yeah, I just want to make a point here, which is that, you know, many people think that once you've been given permission to live and work in the UK, that's it, right? But most people have a limited leave to remain, one way or another, whether you're an asylum seeker or a migrant, and you have to reapply, right? And that doesn't mean that all the rights that you got first time round automatically transfer across. It should do, but it doesn't. So a right to work is one of these things that often falls down the gap in the middle. When you're reapplying to extend your right to remain, and actually somebody says, well, you know, have you still got a right to work? And the Home Office say, well, we don't know. We haven't even thought about it. You know, and you end up getting the sack. You know, the same thing I've seen happen with asylum seekers or refugees, I should say, who've got a stamp in their passport saying they have a right to remain, right? And then their passport expires and they have to get a new passport. And they haven't got that stamp in their new passport. And then suddenly the Home Office are saying, well, if you haven't got the stamp in your new passport, then we don't know whether you got a right to work or not. Except that, of course, they have, because that's been agreed and it's their evidence in their own old passport. But that isn't taken as evidence anymore. So this is why it's so horrendously complicated. And why, in some ways, you know, the point that you made about this isn't an individual issue, it's a collective issue. Why we need to get ahead of the game. It's not just a matter of allowing employers to do what they like, but talking to our members about what the problems are, what they need to have it in a system to make it fair and not make it onerous on them. because all of this stuff, the other point I made, all this stuff can get very expensive. Every time people have to renew their right to residency in the UK, that's about $3,000, And if they want to apply for citizenship, it'll cost you over the period about 12 grand plus, and often for people who are not on very good wages. So we've got a real responsibility to make sure that people aren't abused through the system.
Absolutely, Wilf. All I'd add to that is that we appreciate that workplace reps take on a lot as it is, and you always have your union to go to for advice, for assistance. You can go to the Migrant Rights Network, and you can come to us. It's a massive thing, but don't over stress yourself about it. There's always extra help there to give the support that you need to your members. Okay, we've got another question here from one of our viewers saying that they're currently preparing for a mock audit to ensure it's in preparation for right to work checks, I presume, to get everything in order. Some employees have worked for 20 years for the organisation. How can we treat all right to work checks fairly for both new and old staff so that it's across the board fair for them? And what documents will they need to supply? Katja, have you got any thoughts on that first? How can we make it fair between newer and older staff, some of whom might have been there for 20 years?
So is it for an audit or something like that? Is it like a QP transfer or anything like that? Because the thing is, normally you need to refer to the checks at the time.
It doesn't say anything about 2P. It just says preparing for a mock audit in preparation for UK VI right to work checks. So I don't know, it's just, yeah, I know that normally an employer needs to justify why they want to do a right to work checks on everybody. They need to justify that. So most of the time, sometimes it happens when there's a QP transfer, but otherwise, why would they conduct that? And the thing is, once you've given the reason, obviously, if some people have been here 20 years, I know it's retrospective checks or anything like that, but yeah. It needs to be done consistently and fairly across everybody. But if there's a litigation or anything like that, that person, or if one of the employee is found like not having the right documentation or anything like that, and going through a procedure, that person will have to, or the reps will need to support that person according to the rules at the time. Do you know what I mean? So it's fairly, but at the same time, it's kind of an individual, because it depends when you started employment and what was the rules at the time.
Can I just add in, when some of employers, in order to sort of protect themselves from being accused of not racially discriminating against people, will say, "Oh well, what we'll do is check everybody in the workforce, right? So everybody's subject to the same checks, and then we can't be accused of being discriminatory." And that's just a nonsense. And this is about how actually this kind of regime of fear, which is around these document checks, affects far more people than it needs to. I mean, employers, we should try and make sure that employers only apply document checks to those people that they absolutely have to, in their view. And they should know that, because either they'll be sponsoring people into the workplace, or when they've employed them, people will have had to say, well, here, I've got a right to work, if they've got a proper system for checking that when people are employed. I mean, the real problem that we have often is that, in relation to this, is that for purposes of cheap labour, employers will employ people that they know are vulnerable in this system. that it's not clear what their status is, because they can use that against them. And we've had instances over the years where people who have tried to organise in trade unions, the SOAS cleaners were the most famous example, where actually when they've been effectively organising, suddenly the immigration services turn up and take them away. That's why I say we have to be end of the game. We have to make sure that we say we establish agreements with employers about exactly who is checked and how they're checked and when they're checked, so that actually don't get this blanket approach of everybody's got to be checked, because that causes real problems. Well, that was one of the ways that people ended up getting sort of finding themselves in real problems in the Windrush scandal, when employers suddenly started saying to their workforces, "Oh well, we need to check everybody's documents," and people who had been here for 30 years, but hadn't, for one reason or another, registered themselves as residents in the 80s, were suddenly told, "Oh well, you're not British and you haven't got a right to work." It is complicated. It is problematic. It is a bit of, and I acknowledge what Anna said. It's an extra pressure on already very busy reps. But I think the thing for us to do is, rather than treating it as sort of an individual thing that we respond to when a crisis happens, that we need to be talking to those members and saying, what do you need in this situation from us to help protect you at work?
Absolutely, Wilf. And we apply that method to every subject, really, don't we? Don't fight the fire when it's ablaze. Try and prevent the fire from spreading, or something like that. Okay, we'll see. We've got another question here from a viewer who says that they've got an employer who is reasonably receptive to fairness and inclusion. So would you recommend that they state to their staff their position in advance? For example, "I'm aware this may affect you and may be making you feel very unsafe. So therefore, can I encourage our employer to issue reassurances? Would that be a wise idea?" Let's come back to you first, Katja, and then I'll move to you, Wilf.
Yeah, why not? I think if the employer is showing that they are really supportive to all staff, regardless, and support them in whatever situation, some people might come forward and get that support because they feel quite vulnerable. So yeah, I think it's a good idea. Yeah.
Thanks. And
yeah,
Wilf?
I think it's a very good idea. I'd encourage the employer also to say to people, if there's a problem, we'll help you sort it out, rather than we'll sack you, basically. I think we have to say to employers, look, if you've taken people on, even if there is a problem, we, as far from our point of view, we think you've got a responsibility to help them, rather than seeing them as a problem.
Yeah, absolutely. Thanks, Wilf. And we've had a couple of questions that are related to work visas and sponsorship. Everything you've just said, what is the interaction, if any, between the right to work checks that we've been talking about and visas, sponsorship directly from employers? We'll have this as the last question. So first of all, Katja.
There's nothing different in terms of sponsorship. If you are a sponsorship employer, you have other duties to the people you bring in, but the right to work checks are exactly the same than anybody else. I've seen something around the students. Someone wants to know specifically around that. So if I can just cover that really, really quickly. So students, some of them are permitted to work in the UK, but they have limits on hours they can work during term time. It's between 10 and 20 hours a week, depending on the level of study. But they can work full-time outside the term time. So what the student employer needs to obtain and retain is like the course term and the vacation dates. And what student can do is to provide a printout of the institution website and an email or letter that they have received. And if the course is longer than 1 year, the employer can repeat the checks yearly unless the institution has made available dates for future years. But most of the time it's around August. People are aware of the new timetable. So that's it from.
Thanks. And thank you for answering that extra question about students, because yeah, that was really helpful as well.
I was just going to make the point about students, because I've come across this a lot as well, where students are put under pressure by employers to work more hours than they're allowed to. And then when the employer gets caught, actually it's the student that suffers, right? And gets told that they've not acted in accordance with the rules. So, you know, that's one of the problems about the power relationships in this between employers and employees. You know, so these rules can be used to exploit people as much as anything else. And it's one of the reasons why the TUC have always argued that people's residency status should be completely separated from issues around their employment rights. Because actually, if your employment rights are dependent on your residency status, and actually we're now in a situation where migrant workers, asylum seekers, and refugees don't get permanent residency status unless they've gone through this long, convoluted citizenship process, which costs an arm and a leg. Then you're always going to be vulnerable to people using, you know, the issues around your residency status against you. Yeah, I mean, in terms of sponsorship, Kathy's right, but I think in terms of sponsorship, that employers have even more of a responsibility. You know, they are sponsoring you to be in the UK, you know, and therefore, in terms of ensuring that that actually the documentation is right, that they have a responsibility, especially at the point of renewal as well. And often that's where it falls down, where employers either don't bother to renew the sponsorship, they just forget about it, and people suffer as a result.
Thanks for that, Wilf, and thank you for your thoughts on that also, Katya. We're going to wrap up in a second. There's been a comment in the chat saying, where can I get more information? We will be sharing with you Katya's PowerPoint presentation, which has a huge number of links to further resources. So we'll send that round to you later today, along with a link to the recording of this session. So please do look out for that. If you've registered for this, we will make sure you get the resources. So there's loads of things to look out for. Thank you, Wilf and Katya, for joining us today. You've been really helpful and insightful with lots of fantastic advice for reps in the workplace. Thank you to everyone who's joined us. I know you found it useful. You've been telling us, so thank you again. And I'll see you online again. I think it's next week, possibly the week after next, for another webinar soon. See you again shortly. Bye bye for now.